I would like Christine Chung to throw some light on this subject because she is the head of the South Asian team of the United Nations Human Rights Office in Switzerland. And I remember that she also spoke in Asma Jahangir conference in 2024. So, Christine, please tell us your views about this trend of imposing restrictions on media in the name of national security in the light of international law.
Thank you. I just want to start by saying thank you to the organizers for inviting me to join this very illustrious panel. And this conference is one of my favorite events in Pakistan. So I start by talking about the fundamental human rights issues here. So we are really talking about the right to freedom of expression. And the freedom of expression is an enabling right, because without the right to freedom of expression, people cannot access other human rights. It is essential for a free and democratic society, and the right to freedom of expression is recognized not only in the Universal Declaration of Human Rights, but also international human rights law. We're talking about the International Covenant on Civil and Political Rights and other human rights treaties and other regional human rights treaties. Article 19 of the International Covenant on Civil and Political Rights requires that states guarantee everyone the right to freedom of expression. This includes the freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing or in print, or in the form of art, or through any other media of his or her choice. As such, the freedom of expression encompasses, on the one hand, the right of the public to receive a wide variety of information provided by the media, and on the other hand, the right of the journalists to seek and convey information, as well as to access information on public affairs. The right to, the restrictions, the right to freedom of expression is not absolute, but any restriction to the freedom of expression, it has to be provided by law. It has to pursue a legitimate aim, such as the protection of the rights or reputations of others, the protection of national security, public order, or public health or morals, and it must be necessary and proportionate. Now, when we talk about also counterterrorism, national security, these are also important parts of the legal and regulatory framework of the state. And it is the duty of the state. We have to look at the role of the state. And it's, as the primary duty bearer for human rights, the government also has to protect all individuals within their jurisdiction from acts of terrorism, and they have to safeguard national security. But they also, at the same time, have to abide by human rights law and the obligation to protect the right to freedom of expression, and this includes media freedom. Now, counterterrorism laws, they can be used to violate media freedoms and threaten the safety of journalists. Journalists are often subject to detention, prosecution, and these measures can also result in internet shutdowns. And what's important to keep in mind is that counterterrorism offenses, when they're vague, when they're broadly drafted, this can really bring legitimate reporting activities into suspicion. And they can also criminalize journalism and legitimate expression. And it's the global context in which these measures, the counterterrorism measures, when they're not properly limited, has contributed to the decline in media freedom. UNESCO has said that 85% of the global population has already been affected by these restrictions. I can stop there and go into more detail, I think, after the others have had an opportunity to speak. Thank you.
So now I would like to ask you, how has the concept of national security been used to justify restrictions on the freedom of speech, and where should the line be drawn?
Thank you for that question, a very challenging question. Look, I think the problem is that national security, that states use national security to enact broad, vague legal definitions of terrorism, of extremism, and these are used to restrict civic space and limit human rights. Many states, they persist with these overbroad definitions of terrorism, and what this does is it gives them excessive discretion, not only to misuse the laws against people who are saying things that they don't like, but these laws create uncertainty, and this uncertainty itself creates a chilling effect on freedom of expression and civic participation. And this is all part of a package, right? So these definitions, this legal framework, they also include travel bans, asset freezes, and labeling individuals as terrorists brings them under these restrictions. There's a very low threshold of proof. There's usually a lack of due process and judicial safeguards. I think it's already been mentioned on this panel, the impact in the courts and irregularities go with these situations. And the problems that exist are exacerbated. So we still have excessive pretrial detention. We have denial of access to legal counsel, and essentially reprisals against lawyers for doing their jobs, for defending activists and political opponents. And I guess the other part of the context in which all this is happening, we also have the weaponization of new technologies. There was some reference to this, I think, in the previous panel. But the ability of states to harass and to limit civil society, to limit journalists, the methods have gotten cheaper, easier. Now you can use, personal data collection against journalists, against human rights defenders, against civil society. And also, just to mention before I finish, that there's really, there's also additional gender-based dimensions to all of this. So that, again, the targeting can have particular impact on women. The use of doxing, the use of blackmail, So, I mean, and then there's a whole other element, of course, of within this national security framework of additional cybercrime laws, which you see across the region, but not just across the region, actually globally. I'll stop there.
Okay, thank you.